Ready? Exercise number 14, legal matter. Start. The exclusion of one class of legitimate children from seeking compassionate appointment merely on the ground that the mother of the applicant was the wife of the deceased employee would fail to meet the test of a reasonable nexus with the object sought to be achieved. It would be offensive to and defeat the whole object of ensuring the dignity of the family of a deceased employee who has died in harness. It brings about unconstitutional discrimination between one class of legitimate beneficiaries, legitimate children. Stop, next para. This court held that the scheme and the rules of compassionate appointment cannot violate the mandate of Article 14 of the Constitution. Once Section 16 of the Hindu Marriage Act regards a child born from a marriage entered into while the earlier marriage is subsisting to be legitimate. It would violate Article 14 if the policy or rule excludes such a child from seeking the benefit of compassionate appointment. This circular creates two categories between one class and it has no nexus to the objects sought to be achieved. Once the law has deemed them legitimate, it would be impermissible to exclude them from being considered under the policy. Exclusion of one class of legitimate children would fail to meet the test of nexus with the object, and it would defeat the purpose of ensuring the dignity of the family of the deceased employee. This judgment has now been followed by a number of high courts as well. Stop, next para. Apart from the discrimination ensuing from treating equals unequally, which is writ large as demonstrated in the judgment of this court referred to above. There is also discrimination on the ground of descent, which is expressly prohibited under Article 16 sub 2 in V. Sivyamurthy versus State of AP 3. This court observed that appointments made only on the basis of descent is impermissible. However, compassionate appointments are a well-recognized exception to the general rule if they are carved out in the interest of justice to meet public policy considerations. It lends justification only that far and no further. Stop, next para. While compassionate appointment is an exception to the constitutional guarantee under Article 16, a policy for compassionate appointment must be consistent with the mandate of Articles 14 and 16. That is to say, a policy for compassionate appointment which has the force of law must not discriminate on any of the grounds mentioned in Article 16 sub-article 2, including that of descent. In this regard, descent must be understood to encompass the family's origins of a person. Family's origins include the validity of the marriage of the parents of a claimant of compassionate appointment and the claimant's legitimacy as their child. The court is of opinion that apart from being textually sound, understanding dissent in terms of prohibiting discrimination against a person on the basis of legitimacy or on the basis of his mother's status as a first or second wife within the principles underlying Article 16, Sub Article 2. Stop. Thank you very much.